Your grandmother gave us authority over this estate. We're exercising it.
I've already been in contact with the development group. Resort conversion, conference center, this place is gonna be something.
This is about family!
Foxmere needs leadership. That takes vision, not sentiment.
Did she actually want this?
She wanted the estate in capable hands.
You've never had what it takes to carry this family forward.
$22 million. And I already know exactly what to do with it.
I hope you do.
We chose the right person.
That night, my father stood at the head of the table like a man who had already won. He had paperwork, signatures, $22 million, wrapped in what he believed was an airtight transfer. My brother walked out holding a deed to everything my grandmother spent 50 years building, and neither of them thought to wonder whether the will they were using was actually her last. They never saw me slip away toward the one room in Foxmere they never thought to search. What does a man lose when his certainty turns out to be the thing that destroys him? If you've ever watched someone take what wasn't theirs and call it family, stay with this one. Subscribe so you don't miss what happens next. The drive from Richmond to Charlottesville takes just under 2 hours on a clear afternoon. I had made that drive dozens of times over the years, first as a child who didn't fully understand what Foxmere was, then as a teenager who was beginning to, and finally as an adult who understood it better than anyone in my family seemed comfortable acknowledging. My grandmother's estate sat at the end of a long gravel road lined with oak trees she had planted herself in the 1970s, back when the land was mostly open field and a working vineyard felt closer to a dream than a balance sheet. By the time I was old enough to help, Foxmere Cellars was bottling wine that sold in restaurants across 4 states. The cottage rentals were booked months in advance every summer, and the 2 commercial properties she owned down at Juniper Row were generating steady income without a single vacancy. The place worked because Rosalind made it work. Not by delegating from a distance or hiring people to manage her vision, but by showing up every day and knowing exactly what was happening on every acre of the property. She knew which rows of the vineyard produced the strongest fruit in a dry season. She knew which cottage tenant had a leaky faucet that had gone unreported for 3 weeks. She knew her numbers the way a surgeon knows anatomy, not because she studied them before a meeting, but because they were already part of how she thought. I grew up watching her do it, and somewhere along the way, without quite deciding to, I started learning how to do it too. My father never shared that interest. Warren Bellamy was a man who respected success the way some people respect weather from a distance, as something that simply occurred to certain people and not others. He had strong opinions about legacy and family reputation, about what it meant to carry the Bellamy name forward, but those opinions were mostly theoretical. He managed a regional insurance firm for 30 years and did it competently, but he had no patience for the kind of slow, detailed work that kept a place like Foxmere running. What he did have, what he had always had, was a clear idea of who deserved things and who didn't. And in his mind, that question had always had the same answer. My brother Brennan was 4 years younger than me and had spent most of his adult life testing just how far that answer could stretch. He was charming in the way that people are charming when they've never had to be anything else, quick with a story, easy in a room, confident in a way that looked like competence, until you watched long enough to notice that the projects he described with such enthusiasm rarely survived contact with reality. There had been a food and beverage concept in Charlottesville that closed after 8 months. A short-term rental company he launched with investor money that quietly dissolved 2 years in. A commercial real estate deal that had required our father to make a number of phone calls I was never given the full details of. Each time, the story got rewritten. Each time, Brennan moved on to the next thing with the same certainty he'd brought to the last one. And each time, our parents found a way to stand between him and the consequences. I had stopped waiting for that dynamic to change by the time I was in my mid-20s. I built my own career in real estate operations, acquisition, asset management, working with properties that needed actual oversight rather than enthusiasm, and I kept a deliberate distance from the family's financial entanglements. It wasn't bitterness, exactly. It was something closer to clarity. I knew what my parents thought of me. I was too practical, too direct, too uninterested in performing the kind of warmth they associated with family loyalty. My mother, Lenora, had said as much over the years in the careful, indirect way she preferred comments about how I had always been so independent, delivered in a tone that made independence sound like a character flaw. I had learned to stop arguing with her about it. When Rosalind died, I grieved in the way you grieve someone who was the most fully realized person in your life, not just with sadness, but with a particular kind of disorientation, the feeling of losing the one fixed point you had always navigated by. We had talked on the phone every week. When I visited, we would go over the estate's operating numbers together at her desk, and she would ask my opinion on decisions she had already made, not because she needed my input, but because she wanted me to understand how she thought. I didn't know at the time how deliberate that was. After she passed, my father announced that she had left a will placing him and my mother in charge of the estate as co-executors. He presented this as a matter of course, a formality, an expected arrangement. I had no reason to question it. I had not been included in any conversations about her estate planning, and I did not push to be. If Rosalind had decided to leave matters in my parents' hands, I was willing to accept that. She had known my father her entire adult life. If she had trusted him, I wasn't going to substitute my judgment for hers. 11 months passed. The estate continued operating under an interim management arrangement while my parents handled the administrative transition. Then, about 3 weeks before the dinner, I received a call from my father. He told me the family was getting together at Foxmere, a dinner, nothing formal, just an opportunity to talk about the estate's future direction. He didn't say more than that, and I didn't ask. I marked the date and made the drive. When I arrived, the dining room had been set with the kind of deliberate care that signaled the evening was not as casual as advertised. There were place settings for the four of us, and, at one end of the table, a leather folder I recognized as the kind used by the real estate advisory firm my father had worked with years ago. The folder was thick. A man I didn't know was seated near the window with a briefcase open beside him, making notes on a pad of paper without looking up when I came in. My father waited until we had been seated and the first course had been served before he moved the leather folder to the center of the table. He had the manner of a man who had rehearsed what he was about to say, without quite achieving the ease he was aiming for, his posture too deliberate, his expression too composed. He said that Foxmere was entering a new chapter. He said the estate needed leadership that could meet the scale of what it had become, someone with the vision to take it forward rather than simply maintain it. He said that he and my mother had thought carefully about this, and they were confident they had identified the right person. Then he nodded at Brennan. My brother leaned forward with the relaxed confidence of someone who had already been told what the outcome of this meeting would be. He said he had been in contact with a development group that specialized in luxury resort conversions. He described tearing down 3 of the 6 cottages to make way for expanded guest infrastructure, converting a section of the vineyard to event and hospitality use, and building a conference center on the eastern parcel. He mentioned a financing arrangement, a loan of approximately $5,600,000 secured against the estate itself, as if it were a minor administrative detail rather than a lien on everything Rosalind had spent 50 years building. The whole time he spoke, my father nodded slowly, and my mother watched me with an expression I had seen before, cautious, preemptive, braced for the reaction she expected. I looked at my father and asked him directly whether this was something my grandmother had actually wanted. Not the specific development plan, I meant the larger question. Whether she had imagined Foxmere going this direction. He told me she had given them authority over the estate, and they were exercising it. His voice carried the flat certainty of a man who believed that having legal standing and having moral standing were the same thing. My mother said Brennan would carry the Bellamy name forward, that I should be glad for him. She said it the way you say something you have said many times before without inflection, as if the sentiment had long since been smoothed down to the shape of a habit. Brennan, for his part, did not look at me much during all of this. He signed the transfer documents the advisor placed in front of him with the ease of someone signing for a package delivery. The total value of the estate as reassessed for the transaction was $22 million. I watched my father's pen move across the co-signatory line, and then my mother's, and something settled in me, not anger, not grief, but a very clear understanding of what was actually happening at that table. This was not a family making a difficult decision together. This was a family announcing a decision that had been made somewhere else, in conversations I had not been part of, and presenting it to me as a courtesy. I did not argue. I did not raise my voice or challenge the documents or ask to see the original will. I stayed at the table until the dinner concluded, and then I excused myself. What I wanted was to be in my grandmother's study one more time. Not to look for anything. I had no plan, no suspicion, nothing I could have articulated if someone had asked me why I was walking down that hallway instead of out to my car. I just needed to be in the room where she had done her thinking. Rosalind's study was at the far end of the main house, past the library and the narrow hall that always smelled faintly of the cedar she kept in the closets. The room was largely undisturbed. Her desk sat where it had always sat, under the wide window that faced the eastern vineyard rows, a broad piece of solid walnut that had been in the estate since the 1980s. The leather surface was bare except for a small brass lamp, and the carved wooden tray she had used for incoming correspondence. I sat in her chair. I ran my hand along the edge of the desk the way you touch something when you're trying to remember it rather than use it. The drawer on the left was unlocked and mostly empty, a few pens, a letter opener, a box of paper clips. The drawer on the right held a stack of old financial summaries, quarterly reports from the estate going back several years. I was not looking for anything specific. But when I pulled the right side drawer fully open and noticed that the back wall of the drawer did not align the way it should, sitting perhaps 1/4 of an inch forward of where the frame of the desk ended, I did not ignore it. I pressed the panel at the lower corner, the way you would test whether something was latched rather than flush, and it moved. Behind it was a narrow channel in the wood, no wider than 2 fingers, running the full depth of the drawer frame. Inside, I found 4 things: a folded letter on Rosalind's personal stationery, a small brass key on a plain ring, a document held flat by the narrowness of the space with its edges still sharp, and a sealed envelope with my name written on the front in my grandmother's handwriting. Not the estate's name, not the family's name. Mine, alone, in the careful cursive she used when something mattered. I pulled everything out carefully and set it on the desk under the lamp. I read the document first, because my eyes went to the header before anything else. It read, Last Will and Testament of Rosalind Bellamy. The date on the signature page placed this document nearly 3 years after the will my father had been acting on since her death. The opening clause was short. It said that she revoked all prior wills and testamentary designations in their entirety. I kept reading. The document removed my father and my mother from their roles as executors. It established fixed monetary distributions for them and for Brennan amounts that were generous enough to be meaningful but that represented a fraction of the estate's total value. It stated that the core landholding and operating businesses of Foxmere, including the vineyard, the winery, the cottages, and the Juniper Row properties, were to be transferred in full to me. It named me as the person responsible for the estate's preservation and ongoing operation. And it included a restriction written in plain, unambiguous language, prohibiting the sale or encumbrance of the core land for a defined period following her death. I thought about the papers signed at the dinner table an hour earlier, and I understood what the restriction meant for those papers. The transfer my father had executed, the one Brennan had already begun making plans around, the one apparently attached to a financing arrangement worth more than $5 million, could be legally void. The sealed envelope I held for a long moment without opening. Whatever was inside, it was written directly to me, and I understood instinctively that it was not the same as the letter, which was explanatory, procedural, the kind of document meant to be read alongside the legal paperwork. This envelope was something else. I put it carefully in the breast pocket of my jacket, close, without breaking the seal. Some things deserved more than a hallway and a lamp. I would open it when I was ready. I gathered the letter, the key, and the will, placed them in a document folder I found in the desk's side compartment, and left the house. I walked to my car, set the folder on the passenger seat with the sealed envelope on top, and drove back toward Richmond in the dark. The whole drive, I did not think about what winning looked like. I thought about what my father's face had looked like when he signed those papers, the settled satisfaction of a man who believed he was finalizing something. I thought about the restriction clause in the document beside me, and I thought about the $5,600,000 loan my brother had already committed to in principle, using an asset that might not legally belong to him. And I thought about one line near the end of the letter, not the final line, but one that had stopped me when I reached it. My grandmother had written that she had not hidden this document from everyone. She had hidden it specifically from my father and my brother. She had arranged for a second copy to be held elsewhere, with instructions that it should only be surfaced if someone moved to sell, encumber, or seize control of Foxmere after she was gone. She had known this day might come. She had been ready for it before I was. By the time I reached the highway, I had made my decision. Julian Voss had a reputation in estate law that I had heard about through professional contacts, not because I had ever needed him, but because the kind of work I did in real estate operations brought me into orbit with attorneys who handled high-value property disputes, and his name came up enough times that I had filed it away without quite knowing why. I called him that same night, from the highway, and he agreed to meet me the following morning at his office in Richmond. He did not tell me what he thought while he was reading. He went through the document slowly, page by page, occasionally turning back to recheck a date or cross-reference a clause against another section. His expression stayed neutral in the way that attorneys train themselves to look neutral when they are actually paying close attention. When he finished, he set the pages down in a neat stack, aligned the edges, and looked at me across the desk. He said that what I had brought him was not a handwritten note or an informal expression of intent. It had a case number from a Virginia law firm's filing system, a notary seal, the signatures of 2 witnesses alongside Rosalind's signature, and critically, a reference to a corresponding copy held in external storage. This was a professionally executed testamentary document. Its date placed it nearly 3 years after the will my father had been using as his authority since Rosalind's death. Under Virginia probate law, the more recent will supersede all prior instruments. If the document was authentic, and nothing in its construction suggested otherwise, the transfer my father had executed 2 nights ago was built on a foundation that no longer legally existed. Julian filed for an emergency injunction before noon. The filing requested that all transactions, transfers, encumbrances, and conveyances related to Foxmere Estate be suspended pending a full determination of the governing testamentary instrument. The court granted a temporary restraining order the same afternoon. Brennan had brought a group of 4 people from his development contact to Foxmere that morning, an architect, a financial consultant, and 2 representatives from the resort conversion firm he had aligned himself with. They were walking the eastern parcel of the vineyard, discussing sightlines for the proposed conference structure, when his phone rang. By the time they made it back to the main house, the news had already come through from his own attorney. All development activity, all financing negotiations, and all exercise of ownership rights over the property were halted, effective immediately, pending resolution of a competing probate claim. He called me before I had left Julian's office. I did not answer. The voicemail he left was brief and loud. My parents arrived at my apartment in Richmond 2 evenings later, unannounced, which was something my father did when he wanted to establish that he was still operating from a position of control. My mother sat on the edge of the couch, with her hands folded in her lap, and my father stood near the window with the contained energy of someone who had rehearsed his position on the drive over and was not planning to deviate from it. My father told me he had spent years caring for Rosalind, managing her affairs in her later years, handling the administrative burdens that came with running an estate of that size when her energy was diminishing. He said he had never once seen the document I was now using to challenge everything the family had agreed to. He said it plainly. Not as an accusation yet, but as a statement he wanted on the record between us. My mother was less measured. She said that Rosalind had been a proud woman in her final years, more isolated than she should have been, more susceptible to influence than the family had recognized at the time. She looked at me while she said it, and the implication was not subtle. I had spent more time at Foxmere than anyone else in the family. I had been the one going over the books with her, sitting at that desk, having conversations none of the rest of them were party to. My mother was suggesting, without quite stating it, that proximity and trust could be forms of manipulation and that I had been close enough to both to engineer an outcome. I told her I had found the document in a sealed compartment in Rosalind's desk, that I had not known it existed until the night of the dinner, and that the document spoke for itself. My father said he wanted the matter resisted until the night of the dinner, and that the document spoke for itself. My father said he wanted the matter resolved privately, within the family, before it became something that damaged everyone's reputation. I told him the matter was already in the court's hands. They left without reaching any agreement, and within 48 hours, Brennan had retained his own legal team, 4 attorneys from a firm that specialized in contested estate litigation. Julian and I went through Rosalind's letter together a few days later. Sitting across from him at the conference table in his office, I read it aloud while he took notes. It was 7 pages, written across several sessions. You could tell by the slight variation in ink density and the fact that 2 of the pages were dated, though not all of them were. She had organized her thoughts the way she organized everything, by sequence, by relevance, without wasted words. She explained that in the 2 years before her death, my father had approached her multiple times with requests that followed a recognizable pattern. He wanted her to liquidate part of the vineyard holdings and redirect those funds into a venture Brennan was developing. He wanted her to authorize Brennan to sit on the operating board of Foxmere Cellars in a capacity that would give him effective control over the winery's financial decisions. She had declined each time. The event that made her act was something she described with restraint but without softening. She had been reviewing the estate's operating accounts, something she still did herself, because she did not believe in delegating the things that mattered most when she found a series of transfers she had not approved. The amounts were not individually large, but they were consistent in their timing and their destination, accounts associated with a holding company that Brennan controlled. When she confronted my father, he told her the transfers had been authorized under the General Financial Management Authority she had granted him. She had told him, in terms she wrote down without apparent regret, that she was revoking that authority immediately. After that conversation, she changed the will. The small brass key I had found in the desk led to a fireproof safe installed in the wall of the storage room adjacent to the study, behind a set of shelving units holding archived issues of the estate's wine club newsletters going back to the early 2000s. Inside was a manila folder, organized with the same precision she brought to everything, a chronological log of the transactions that had concerned her, with dates, amounts, account numbers, authorization codes, and her own handwritten notes beside each entry describing what the transfer appeared to fund and why she found it irregular. Julian sent the folder to an independent forensic accounting firm the same week. He requested through the court that a full financial audit of the estate's operating accounts be conducted as part of the probate proceedings, a standard request in a contested estate matter of this complexity, and one that the court granted without objection. The preliminary results identified approximately $1,370,000 that had been transferred or committed from accounts connected to Foxmere to entities under Brennan's control during the final years of Rosalind's life, the majority authorized through approvals bearing my father's signature. The story had shifted. This was no longer simply a question of which will govern the estate. The question underneath it was whether my father had knowingly used a superseded document to execute a transfer he had reason to believe might not be legally his to make. While the audit was underway, Brennan's legal team found Daphne Rowe. She had worked as Rosalind's housekeeper for nearly 2 decades and had been one of the 2 people who witnessed the signing of the revised will. The other witness, a retired attorney who had been a longtime personal friend of Rosalind's, had died the previous year. Daphne remembered the signing clearly in its essentials. She remembered being asked to witness a document, remembered Rosalind's signature going down on the page, remembered that it felt serious and deliberate. But when opposing counsel pressed her on specifics, the exact date, the number of people in the room, the precise sequence of who signed when she was less certain. She was in her late 70s, the event had occurred several years earlier, and she had not known she might one day need to reconstruct it in detail before a judge. It was enough for Brennan's attorneys to work with. They filed a supplemental brief arguing that the sole surviving witness could not testify with confidence to the procedural integrity of the signing. They also raised the question of the document's physical custody. It had been stored inside Foxmere itself, in a location only I appeared to know about during a time when I had regular access to the estate. They did not accuse me directly. They did not need to. The implication was constructed carefully enough to function without the explicit statement. My mother signed a formal declaration supporting Brennan's position. In it, she stated that Rosalind had told her on more than one occasion that the estate should remain in the Bellamy family through the male line. She signed it without calling me first, without any conversation, without giving me the chance to hear it from her before it entered the legal record. That was the part that stayed with me longest, not that she disagreed with me, but that she had made her choice and submitted it in writing before I even knew she had been asked. Brennan met me for coffee in Charlottesville a few weeks after the first hearing. He arrived before me and was already seated when I came in, tired in a way that had not been visible at the dinner, carrying the particular exhaustion of someone who had planned extensively for a future that had since been placed in legal suspension. He said he understood the will I had found might be legitimate. He said it carefully, as a concession rather than a conviction. He said that a prolonged court battle would damage the estate costs, operational disruption, the uncertainty driving away Foxmere's sellers, accounts that depended on stable relationships. He said that the people who worked on the property would pay the price for a dispute between two people who were supposed to be family. Then he made his offer. If I withdrew the legal challenge and allowed him to take control of the estate as originally planned, he would give me a cash settlement equal to 20% of the estate's assessed value. He framed it as a fair resolution, as a way to honor what Rosalind might have wanted without tearing the family apart. I thought about what 20% represented not as an abstract sum, but as what it meant against what was being traded for it. The vineyard. The winery. The cottages. The land itself, which could not be rebuilt or relocated. The restriction clause in Rosalind's will, which existed specifically because she had understood what my brother would do if he got access to it. I told him no. He was quiet for a moment, looking at his coffee. When he looked up, something in his expression had shifted not to anger, but to a cold acknowledgement, the look of someone recalculating rather than feeling. He told me that if Foxmere deteriorated during a years-long legal proceeding, that would be on me. He said I was the one choosing to let it happen. Then he picked up the check for both coffees and left. My father came to my office in Richmond about a week later, unannounced again. He sat across from my desk in the chair where clients usually sat and made his own offer. Split the estate, give Brennan operational control of half the landholding, and the family would drop the contest entirely. He said the legal fees and audit costs were already beginning to reduce the estate's liquid reserves. He said that continuing to fight would cost me more than it cost Brennan, because Brennan had nothing to lose and I was the one who claimed to care about preserving the place. It was the most precise thing my father had said to me in years. He was right that I cared more than Brennan did. He was using that as leverage, and he knew it, and he was sitting in my office offering me the chance to stop the bleeding at the cost of half of what Rosalind had specifically decided he should not control. I asked him whether he had known, when he presented himself to the court as executor under the earlier will, that a later document existed. He said that was not a relevant question. I told him I thought it was the only relevant question and that I would see him in court. After he left, I sat at my desk without doing anything else for a long time. The audit report was still weeks away. Everything was slow in the way that legal processes are slow, deliberate, procedural, immune to urgency, regardless of what was actually at stake. I had made the right decision. I believed that with enough certainty that I had not seriously reconsidered it since the drive back from Foxmere. But there is a difference between knowing you are right and not feeling the weight of what being right is costing you, and that night I felt the weight. The letter had been with me since the night I found it. I had read it in full twice, once at Julian's office when we went through it together for his notes, and once alone a few weeks later, when the weight of the proceedings had reached the point where I needed to go back to the source of why I had started any of this. But there was one line near the end that I had read and moved past without fully working out what it meant. I had registered it the way you register something that doesn't yet have a context to land in noting it, filing it, leaving it for later. In the weeks since my father's visit to my office, with the audit still pending and the next hearing still weeks away, I found myself returning to it in the early mornings before I started work, sitting at my kitchen table with the letter and a cup of coffee, reading that single line again. She had written, "If they force you to prove what I meant, find where I sent my words instead of my papers." I had assumed, the first several times I read it, that she was referring to the Crescent Archive storage, the external location where a second copy of the will was presumably held, which Julian had already identified through the reference in the will itself. But the phrasing didn't quite fit. A second copy of the will was still a paper. It was documentation, not words. The distinction she was drawing, I started to think, was more specific than I had given it credit for. I called Julian on a Wednesday morning and read him the line directly. He said he wanted to go back through the file his office had on Rosalind's account with Crescent Archive Services. He had retrieved the will copy from there already, but the retrieval had been conducted under time pressure, focused specifically on the testamentary documents. He wanted to know whether she had stored anything else in that account. It took 2 days to get the full inventory from Crescent. When Julian called me back, his voice had the contained quality it took on when something significant had come in. He told me the archive account contained 3 separately sealed items, not one. The first was the will copy he had already retrieved. The second was a sealed medical file. The third was a storage drive in a protective case, accompanied by a printed note in Rosalind's handwriting that read, "To be opened only in the event of a legal challenge to the revised will." We drove to Charlottesville together to retrieve them. The medical file was organized the way Rosalind organized everything, labeled on the outside with the contents and date, no unnecessary information, nothing left to interpretation. Inside was a formal cognitive assessment conducted by an independent neurologist at a private practice in Charlottesville, dated 11 days before the revised will was signed. The assessment covered orientation, memory, executive function, reasoning, and decisional capacity. The concluding section ran to 3 paragraphs, and its language was precise. Rosalind Bellamy demonstrated full cognitive integrity at the time of evaluation, with no indicators of impairment, confusion, or susceptibility to external direction. She was assessed as possessing complete capacity to understand the nature and consequences of a testamentary decision, including the financial scope of the assets involved and the legal effect of the designations she intended to make. Brennan's legal team had built a significant portion of their challenge on the premise that Rosalind had been an aging woman whose decisions in her final years may have been shaped by proximity and influence rather than genuine, independent intent. That argument required a version of Rosalind in which her faculties had been compromised, her judgment softened, her will susceptible to the pressure of someone she trusted. The document in my hands described a different woman entirely, one who had anticipated that argument and taken deliberate steps to preempt it more than a week before she signed the revised will. The storage drive required a laptop to open. Julian had brought one. We sat in the small private room Crescent provided for document review, and he inserted the drive while I stood behind him. There was a single video file on the drive, labeled with the date of the will signing, and nothing else. He opened it. The footage was not professionally produced, but it was clear. It had been recorded on a standard camera set on a tripod in what I recognized as the conference room of the law firm that had administered the will signing. Rosalind sat at the near end of a table, with her attorney seated to her left and a second person partially visible at the table's edge. She was dressed in the way she dressed for any meeting she considered important, composed, deliberate, no concession to informality. She looked exactly like herself. Her attorney began by asking her to confirm, for the record, that she understood the purpose of the session and was participating of her own volition. She confirmed it without hesitation. He asked her to state, in her own words, the nature of the document she had signed that day. She described it accurately and completely: the revocation of prior instruments, the redistribution of assets, the appointment of a new executor, the protective restriction on the core landholding. She used the correct legal terminology without being prompted, because she had always been precise about language. Then her attorney asked the question that had been sitting at the center of every filing and every hearing and every conversation I had been part of for the past several months. He asked her why she had chosen not to leave Foxmere to Warren or to Brennan. She did not look away from the camera when she answered. She said, "Because they see what the land is worth. Adrian sees what it costs." She went on, in the same measured tone, to explain that her decision was not punitive. Brennan would receive a meaningful inheritance. She had structured it that way, deliberately, because she did not believe in leaving people with nothing, and because she understood that his limitations were partly a product of having never been required to live with consequences. But Foxmere itself required a different kind of stewardship than Brennan was capable of providing, not because he lacked intelligence, but because he had spent his life asking what things could give him rather than what he owed them. She said she had watched that clearly and without illusion for many years, and she was not going to let sentimentality override what she knew to be true. She also spoke about my father. She said Warren was a man who had spent decades believing that managing something and understanding it were the same thing. She said that if he retained control of Foxmere's finances after her death, the estate would be leveraged and restructured within a decade in service of plans that looked like growth and functioned like extraction, and there would be nothing left to pass on to anyone. She said she had tried to address this directly with him while she was alive, and that the outcome of those conversations had confirmed rather than changed her assessment. I watched the full recording twice. The second time, I did not take any notes. I just watched her, the stillness of her hands on the table, the evenness of her voice, the complete absence of anything resembling doubt or hesitation. She had done this on purpose. She had walked into that room knowing exactly what she was doing and why, and she had put it on record in her own voice so that no filing, no deposition, no affidavit from my mother could replace what she had actually said with something more convenient. Sitting in that small Crescent review room, I understood for the first time what she had meant by the line in the letter. She had not sent me to more papers. She had sent me to her voice. The words she had put into that room, on that day, spoken directly to a camera she knew I might eventually need to see, those were what she meant when she said words instead of papers. She had known, with the same precision she brought to exactly what would be needed to answer it. Julian made copies of everything and filed them with the court within 48 hours. Before the final hearing, he contacted Daphne Rowe again, not to redepose her, but to give her the opportunity to see the video, in case anything in it affected what she recalled from the signing day. She watched the full recording without interrupting. When it finished, she sat for a moment with her hands folded in her lap and then said something that had not come up in her earlier deposition, because no one had thought to ask the right question. She said she did not remember every detail of the signing itself. That was true, but she remembered clearly what Rosalind had said to her when it was over. She said Rosalind had looked at her directly, before they left the room, and said, "Daphne, make sure you remember today. Today I did what needed doing." It did not alter the documentary record. The second will copy, and the cognitive assessment and the video had already done that work. But it answered something that had been left open, the question of whether Rosalind had experienced the day of signing as something imposed on her or as something she had chosen. What Daphne described was a woman who had finished something she set out to do and felt the particular steadiness of having done it correctly. The final hearing was held on a Tuesday morning in a courtroom in Charlottesville. Julian presented the full body of evidence in sequence. The second original will from Crescent Archive, which established that the document had never been in my custody or control prior to discovery. The cognitive assessment, which established Rosalind's complete decisional capacity at the time of signing. And the video, which established her intent, her reasoning, and her awareness of the legal consequences of her decisions in her own words and her own voice. He also submitted the completed forensic audit, which had by then produced a final figure. $1,400,000 in funds drawn from Foxmere's operating accounts had been transferred or committed to entities under Brennan's control during the final years of Rosalind's life, the majority authorized through approvals bearing my father's signature. The ruling came at the end of the same session. The court recognized the revised will as the valid and controlling expression of Rosalind Bellamy's testamentary intent. All prior instruments were superseded and carried no legal force. The transfer documents signed at the dinner, the ones my father and mother had executed in favor of Brennan, were declared void from the beginning, meaning they had never had legal effect regardless of when the challenge was filed. Neither I nor Brennan had been recognized as having ownership rights during the dispute period, but with the ruling in place, the court-appointed administrator's oversight would continue only through the formal transfer process, after which I would assume full ownership and operational authority over Foxmere Estate and all associated entities. The loan Brennan had been attempting to secure against the estate had never been finalized, because the ownership dispute had surfaced before the institution completed its underwriting. With the transfer now void, there was no collateral and no borrower with any claim to it. The development group had withdrawn months earlier. There was nothing left of the resort conversion plan except a set of architectural sketches that belonged to a project that no longer had a site. The audit findings were referred for further review. My father, as the person who had exercised financial management authority over the estate during the period in question, and whose signature appeared on the majority of the irregular transfers, was required to account for the funds and make the estate whole. The total obligation, after accounting for applicable costs, exceeded $1,400,000. The inheritance Rosalind had designated for Brennan was applied against the liability he had helped create. My father did not speak to me after the ruling. He left the courtroom with his attorney without acknowledgement. My mother had not attended. Brennan sat near the back of the room for most of the session and was gone before I reached the hallway. Julian and I stood outside the courthouse for a few minutes in the early afternoon light. He said the formal transfer would take several weeks, but that he expected it to proceed without obstruction. I thanked him, which felt inadequate for what it represented, and he said something I thought was true, that Rosalind had done most of the work herself. All he had done was make sure it reached the right room. I drove to Foxmere that afternoon. The administrator walked me through the operational status, which accounts were current, which vendor relationships needed attention, which Foxmere sellers' contracts were running on informal extensions and needed to be formalized. I took notes on everything. We walked the property as the light was dropping, moving through the vineyard rows and past the cottages and down toward the juniper row parcels on the south end, and I paid attention to what needed immediate care and what could wait. In the weeks that followed, I began putting things back in order. The 3 cottages Brennan had planned to demolish were evaluated and found structurally sound. I engaged a contractor to handle deferred maintenance, and by the following spring, all 6 were back in full operation. The Foxmere sellers' distribution relationships running on informal extensions were reviewed, renegotiated where necessary, and brought into formal agreements. The Juniper Row properties were released on long-term contracts to commercial tenants whose businesses fit the surrounding area. I also established something Rosalind had talked about for years without formalizing a structured apprenticeship and education fund for the children of long-term estate employees. I set it up in her name. 2 years after the ruling, Foxmere's operating revenues were measurably higher than they had been under my father's management. Not because I had introduced anything dramatic or transformative, but because I had stopped what was draining it and let what worked continue to work. The vineyard still produced what it had always produced. The winery still made what it had always made. The land was still what it had always been. What changed was that no one was trying to turn it into something else. One afternoon in the second year, I went back to Rosalind's study. I had been using it as my own office since moving to Foxmere, the walnut desk, the lamp, the view of the eastern vineyard through the wide window. The hidden compartment behind the drawer was empty now, had been since the night I found it. I took out the sealed envelope I had carried in my jacket pocket since that night. I had waited, the way she had taught me to wait for the right moment. I opened it carefully. Inside was a single folded card, not legal paper, not stationery. Just a card, the kind she kept in the small drawer of her bedside table, the ones she used for birthdays and small notes passed across the dinner table when she was trying not to make something into a speech. In her handwriting, she had written 4 sentences. She wrote that she knew I would be the one to find this, because I was always the one who came back to check on things after everyone else had left. She wrote that she was not sorry for what she was asking me to carry, because she believed I had been carrying it already without being asked. She wrote that Foxmere did not need to be saved, it just needed someone who understood that keeping something alive was its own form of building. And at the bottom, beneath her signature, she had added one final line that she had also put into the letter. I had already framed as though she wanted me to find it twice, in 2 different places, once in the context of evidence and once in the context of just the 2 of us. An inheritance is not proof that you were loved more. It is proof that someone trusted you with what they could no longer protect. I sat with that for a long time. Then I put the card back in the envelope and placed it in the center drawer of her desk, not hidden, not locked away, just kept close. My brother had always asked what Foxmere could give him. My father had always asked what they could do with its value. I was the only one who had ever asked my grandmother a different question. What would it take to make sure this place was still standing long after we were gone? That question was why she chose me. Not as a reward. Not as a punishment to anyone else. As an answer to the thing she had spent 50 years trying to solve. If there is anything this story leaves behind, I think it is this. The people who deserve to carry something forward are not always the ones who ask for it the loudest or who get told they deserve it the most. Sometimes they are the ones who have been quietly learning the weight of it while everyone else was arguing about the price. Rosalind knew the difference. In the end, so did the court. And so finally, did I. If this story stayed with you, if you've ever watched someone confuse entitlement with deserve, or seen a family choose the wrong person for the wrong reasons, share it with someone who needs to hear it. Subscribe if you haven't already. There are more stories like this one, and every one of them is about what people reveal when real stakes are finally on the table.